When you go into the Department of Accounting and you do tax 1 and tax 2, or you do an HDIP tax, you think that you're getting into a wonderful world where accountants become lawyers, and they get involved in all the heavy law that gets involved in tax. Now, that was in a day when people used to take tax matters to court. If you look at the cost of a legal tax dispute today, you can easily knock up 5 million rand in legal fees, win or lose, and it will take you 10 years to settle your problems through the court systems in South Africa. For anybody who's in this classroom, I can tell you something, that if somebody says to you that one day that every taxpayer is due his day in court, it's a famous saying, your answer to him is, bullshit, I can't afford it. Only a mega corporation is able to afford it. Now let's take it back and go to a legendary character we'll call Oscar Pistorius this morning. What did we learn from Oscar Pistorius? What we learned from Oscar Pistorius is one thing. South Africa is not a place to get into trouble. We do not have quick and ready access to courts. And anybody, any trader who gets frustrated with their tax affairs can very quickly and think, well, I'm off to see a lawyer. I'm off to see the advocates, they will say. And what do they come back with? A big bill. And a matter that can't ever get settled. The stress about that, and stress and income tax, is one of the biggest killers of businessmen. Do you know, I had a case years ago where a client had a heart attack because he got a letter from SARS. The letter wasn't even opened. And in fact, back in those days when we opened it, we found it to be a refund check. But people just see SARS and they freak out. And sooner or later, as we discovered in yesterday's lectures, you will find that you're going to come across this thing, SARS. You have to be registered with SARS if you are going to be of any substance in the business community. One of the first things that you are asked for example, when you do a tender, is a tax clearance certificate. If you don't have a tax clearance certificate, well, do not pass go, do not collect 300. Goodbye, you will not get any further in this matter. So we have to find a way of managing the system. And what we have to learn is tax management, not tax. One of the greatest things about Pravin Gordhan is Pravin Gordhan is not and never was a tax specialist. What's his official qualification? Anybody in the class know? He's a pharmacist. He was a pharmacist activist. On the day that the capitulation of South Africa was announced in 1990, Pravin Gordhan was detained in jail in the Free State. That's where he comes from. And when he took over as Commissioner of Inland Revenue, everybody thought this is a disaster in the making. But Pravin Gordhan's clever. He managed tax. He says, with my budget, I can buy as many tax nerds as I want. The universities push them out every year. I'll hire them. So if you ever worked on a forum with Gordhan or something like that, it was quite interesting. He would simply say, I'm not answering that question. Matthew, you know about tax, you do it. It was incredible. So that was tax management. And in a PDEM like this, in a course like this, we can't teach you the Income Tax Act. If you want to do income tax and study it, the Act, just the Income Tax Act, is 700 pages long. That's before you get to the VAT Act, the Tax Administration Act, and all the other acts that go with income tax. So how are you going to deal with this? The answer, the Americans caught on to this a long, long time ago, is what you concentrate on in tax is that you concentrate on delegating the problem. So many SMEs spend hours and hours and hours trying to do their tax themselves, and they spend so long on it that they actually affect their business. If you are an SME, your job is to get out there and trade. And this is another reason why you need to grow SMEs above the informal sector, so that you can hire the resources that you need to get this thing going. Right. Now, when you do a traditional tax course, it starts off with Section 1 of the Income Tax Act, gross income. I don't teach tax like that. I teach tax from the point of view of how do you administer it. And you start off in the administration of tax with not the Income Tax Act, but the Tax Administration Act. That is the act that regulates how you and SARS behave with each other. It gives SARS rights and it gives you rights. And you need to know your rights as a taxpayer probably more than you need to know how tax actually works and the calculations and everything else. So before we even get on to teaching any income tax this morning, we're going to start looking at what is tax administration all about. And it starts off with a debate that is very current in the press at the moment. Who are the players in the game? Okay, now that is important because you need to know who you're dealing with. Okay, so it starts like this. We have to have the overall layout of National Treasury and SARS. They are two different animals and people get this confused all the time. Right. So we have Parliament, which is established in terms of a constitution. And we also have a president who is appointed. Now he starts making his appointments and he appoints the SARS commissioner. And the SARS commissioner is independent of another presidential appointment, which is the Minister of Finance. Now just stop at that point. This is where the row between Gordon and the president happened. What he's saying is the state president appoints the Minister of Finance, but he also appoints the SARS commissioner. And Gordon had a different interpretation on that because that legislation runs in contrast with your constitution, which says basically that only the Minister of Finance can appoint the Commissioner of Inland Revenue. And that's the whole fight between Gordon and Munyani. Munyani got appointed by the president, and he arrived, and Gordon said, well, let's talk. Munyani says, I'm not talking to you. I'm responsible to the state president. Go get stuffed. And that's where the friction between the two started, right? Now, what is the role of the Minister of Finance? The role of the Minister of Finance is to run what the Department of National Treasury. Now, National Treasury, their job is to assess how much money South African government is going to spend and where, and what is the overriding tax policy that is needed and the legislation that is needed to go and collect that money. They're not responsible for collecting it. And then they report back to Parliament, to the Portfolio Committee of Parliament, and they say, we need this rule, we need this tax rate, etc., etc. That is done by National Treasury. The SARS Commissioner is charged with collecting the taxes in terms of the laws laid down by National Treasury. So the SARS Commissioner is appointed, and then he appoints two breeds of nerds that work for SARS. There are a handful of what are called senior tax officers. Now take note. That person is very important. There are certain documents issued by SARS that are not valid because they can only be signed by a senior tax officer. We're going to see that name come up quite a few times in this presentation this morning, where the senior tax officers are only entitled to make a decision. And then there are rafts of all other forms of animals at SARS called tax officers. They have very limited powers. So what you take from that thing is your decision-making ability in SARS is carried out by your senior tax officers, not your tax officer. And you've got to be careful with that, because when you deal with a SARS official and it is not a senior tax officer, you can't come to any decision with that person. He has to get it signed off by his boss. Otherwise, it's not valid. And, I'll give you an example of this, that during tax inspections, we sometimes get a case where the people carrying out a tax inspection say, okay, well, we'll accept this, or we propose that we settle something this way or that way. They're not entitled to do it. What they think actually means, fuck all. You have to get it signed off by a senior tax officer. And then we have another funny guy running around, the tax ombud. The tax ombud's job is to wander around SARS and monitor the whole system and report back to the Minister of Finance and the portfolio committees as to how the tax system is operating. He's got other rights, but that would be something that you deal with at a high level. So, I quite often get it, where people say to me, Matthew, I'm sick of this, of what SARS is doing to me. I'm going to talk to the Minister of Finance. What can the Minister of Finance do? Nothing. You have to go through the SARS channels. You might be able to raise a complaint with the tax ombud, and he might take it to the Minister of Finance. But actually, here's a funny thing. The Minister of Finance cannot even look at your tax file. Only the Commissioner can do that. Very interesting relationship. Now, if you look at the powers of the Commissioner, this is quite important in the current debate that we are having in South Africa. The Commissioner has all sorts of powers set out. Generally, he's empowered to collect the act and make delegations, appoint his senior tax officers, and then there are all sorts of powers that he can delegate down to his officials. Importantly, Section 6 deals with relationships within SARS. Section 7 is an interesting section, the question of a conflict of interest with a SARS official. If I am related to a SARS official, he's not allowed to even touch my file. He must say, I've got a conflict of interest there, I will hand that file over to somebody else. So there is a specific provision which stops SARS officials meddling in family affairs or friends or whatever. They have to maintain a level of independence in what they are doing. We'll come back to that a little bit later. Then we carry on. Absolutely critical, especially in SME. All SARS officials have to carry identity cards. And you will see this in SME, where suddenly, without notice, a man will walk through your doors and say, I'm from SARS, I'd like to talk to you. To which your response is, first thing, show me your identity card. Because there have been many cases of SARS officials masquerading, or members of the public masquerading as revenue officials. And they are looking for bribes. If you give me 1,000 rand, I'll walk away from this inspection, you'll never see me again. So the person hands over 1,000 rand. Why? Because they're terrified. Now, here is a question, here is a tip for you. A SARS official is not allowed out of his office without permission from a senior tax officer, other than when they're doing a walkabout. They are never allowed to go on inspections alone. There have to be two of them. Identity cards first, before you take anything anywhere further forward, identity card. If it is a true SARS official, they'll have no problem with that because you're verifying that they are from SARS and you're getting around this problem of fraudulent transactions. Please understand in everything that we're doing in this course, why is SARS so on the defensive all the time? SARS is the biggest target of fraud in this country. More fraudulent claims are made against SARS every day than you can imagine, particularly through the VAT system. People claiming VAT refunds and all sorts of things. And this is why there have to be the quality controls to make sure that when you're dealing with a SARS official, it is a genuine SARS official and not somebody masquerading as them. Section 9 also gives the powers within SARS to make decisions, and that is generally given to the senior tax officers. Don't worry about delegations, civil actions, and court appearances. Those are all just permissions. So what we've learned so far is a SARS official has to carry an identity card, and if he can't produce it, out. Walk off, out of here. Okay? You're entitled to do that. Okay? And we'll see that there are even more quality controls that will come into this as we go along. The Minister of Finance, his job is to go out there and determine the economic policy of South Africa and write the tax acts which SARS will enforce. The Minister of Finance cannot walk around SARS in terms of the Tax Administration Act. He can only get general statistics as to what SARS has collected. And then we have provisions relating to get delegations of staff, etc. That's all internal with SARS. Then we have the tax ombud. The tax ombud works on behalf of the Minister of Finance. He is monitoring everything that is going on, and he will basically see and report back to SARS, to the Parliament as to what's going on. You might have seen recently with the tax ombud that there was the row about SARS withholding refunds in March of this year to boost their tax figures. And so many complaints were lodged with the tax ombud that he took this on and he said, I'm going to write a special report. I'm going to go and see, why is SARS hanging on to money? Is this necessary? And the excuse given out by SARS was, most of the refunds that we are withholding are for VAT, and we know that there is an enormous incidence of fraud with VAT, and the Ombud didn't buy all of that. He said the position is out of hand. So there are provisions relating to the appointment mandate and exclusions and reviews of the Ombud. Now, be careful when people talk to you about the Ombud. They think that if you're not happy with SARS, you can just run into the Ombud's office and complain, and he will overrule SARS. He doesn't have the power to overrule SARS. He can make a recommendation as to how he thinks the matter should be handled. But we can't have the Ombud overruling. He has limited powers in South Africa. He has access to SARS information and has confidentiality provisions, but that's about it. And he reports to the Minister of Finance. But the Ombud is not going to save you as an SME. So that's part one. Those are the people. What you learned is that you will be dealing with SARS officials. First thing first, if anyone ever appears, may please produce an identity document. We now go over to the corresponding provisions which deal with taxpayers' registration, records, and submission of returns. So it starts off at section 22, which says, you will apply for a tax number. Now, people think that there are all sorts of de minimis rules, and SARS will not worry about this. If you receive R1 of trade income, you are technically required to register for tax. There is no de minimis rule. Now, when we've got micro businesses, that doesn't absolve them from registering. Now, do you imagine if you walk down High Street here in Grahamstown today, that you will see micro businesses all with tax numbers? Of course not. What the Act does is it allows SARS to not insist. Technically, a small business such as that should be registered under the micro-business registration thresholds, which we looked at in the first lectures in this course. They put in 2 tiny returns a year. If their turnover is less than 335,000 Rand, then that's it. They don't need to take it any further. But not many do. In fact, in the whole of South Africa, there are less than 10,000 micro businesses who've ever bothered to register for tax. It's appalling, but that's the way it goes. So, it's your obligation to communicate with SARS any change in details within 21 days of them happening. That's whether you have received income or whether you have changed your addresses. Very importantly, you've got 21 days to notify SARS. A lot of people don't do that. It doesn't mean that SARS is going to go out charging everybody if they didn't notify change of address. What is going to happen, though, is if there ever is a problem with SARS and you haven't given them the correct address, then there can be high jump for that. So, right, how do we come to submit returns? In terms of Section 25, every year the Commissioner puts out a notice to the public that you are required to submit returns. That is what you see in the press as being filing season and all over the radio. So the tax year ends on 28th of February, and filing season for submission of your returns generally opens on the 1st of July. And you have then got to put in a return if you are in business by the end of January of the following year. It's not up to SARS to send you a return. They don't. You download it off your e-filing portal. They'll put out an announcement and they say, go onto your e-filing portal, download the return and submit it. They don't have to send you a return or threaten you. They may also ask a business to create third-party returns. What third-party returns are is where, for example, you are an estate agent and you are managing a rental book. SARS can ask you to produce your rental book, and the figures that are there, they can get it from a third party in terms of Section 26. They may also, there are other technical provisions for other returns that they can make. Section 28, they can require you to submit information under oath and make a statement on your accounts. Or they can acquire anybody else who has prepared tax information on your behalf to also make a statement. So they can come to the accountant and say, make a sworn statement as to what was your part in preparing these returns, so that, you know, we can see who did what and when. Next up, very importantly in an SME, is Section 29, your duty to keep books and records. Now, under the Companies Act, you are required to keep certain books and records. But under the Income Tax Act, there are more stringent and more specific duties to keep books and records. Now, you're required to keep books and records, and technically it's an offense not to keep books and records. What it does, though, the presence of Section 29 says, if you haven't kept books and records, you are going to be on the back foot when it comes to a dispute with SARS. And not keeping proper books and records or not having them available is not going to be an excuse. So can you see the pressures mounting here? It's your duty to register for all the taxes that you need to pay. It's your duty to keep proper books and records. Is there a provision here that says SARS is going to pay you to keep proper books and records? No. That is a cost of doing business. It has been estimated that this cost is as much as 8% of the total turnover of SMEs in South Africa. The cost of keeping your books of records straight. And all the politicians the world over, they talk about red tape. We're going to reduce red tape. And what happens every year? It increases. And they have completely failed to stop you from keeping proper, in their attempt to streamline it. So, your records must be retained in an orderly fashion and in a safe place. You can keep them in electronic form if you want to, okay, or other form which is specifically approved by a senior SARS official. So you have to keep proper books and records. Why do you keep proper books and records? So that SARS can inspect them. Now, this is where the blood level, sugar levels start going up, okay? People start freaking out. We've got a SARS inspector coming along. Now, there are specific rules with regard to inspections. 30 years ago, when SARS officials ever came out of their office, it was generally you said, hey, let's have a beer over this and go and have an expensive lunch. And we got so pissed they never came back. But now, you've got to be careful. So we are saying, records must be kept and be kept available for inspection by a SARS official in the Republic for the purposes of determining your compliance with the Income Tax Act or for inspection, audit, or investigation. We have access to your books. Does that mean that SARS can walk up to a person in the middle of the street and say, give me your books and records, and start auditing them there and then? No. Once you have your records, those are yours. And our Constitution is very specific about your right to privacy. And when your privacy is in any way invaded by any government organization, it has to be done with due care and under strict provisions of the Act. So, what would happen if a SARS official arrived at my house in the middle of the night and said, I want to do an inspection? What do I say? Fuck off. Okay? That is the overriding presumption. Make an appointment. We will see that that rule varies as we go along. Okay? That's not a rule that's entrenched in stone. But they have to be careful. You have to retain books and records, generally for 5 years. And if you are involved in a dispute, or an audit, or an appeal to court, all of which we'll do in the next couple of days, then you have to retain those records indefinitely. And SARS may require that they are translated if you are trying to keep them in some sort of secret code. We don't see that happening often. Now, we move on to the next part, which is now SARS wants to inspect your books and records. Now, this is getting dangerous. Selection for inspection, verification, or audit. SARS may select on the basis of any consideration relevant who will be audited. Now, have any of you read the book Rogue Unit? We sold 23,000 copies of it. Gordon established a special investigation unit in SARS to go and look at the major problems that we have in South Africa with contraband. And this started doing some serious spying around the place. And people say, I get audited every year. And you say, well, SARS is doing its job properly then, isn't it? They can select for audit on any situation that they see as being a point of risk. So some taxpayers who only have an IRP5 from their employers, they're no risk to SARS. There's no other income that they could have. So for years, they might get a little query here or there, but nothing much. There are others who have risky businesses where SARS inspects them once a year for income tax, and 6 times a year for value-added tax. Why? Because they're high risk. And SARS may use any basis that they want for selecting people for audit. That's no excuse. And what the fuss was about, because Gordon went out there and said, I want a rogue unit to investigate a specific high-risk transaction. Well, that's exactly what Section 40 of the Act says. So, SARS can do what they want, but this can also lead to a little bit of mischief. You won't believe how many people in South Africa believe that they can get vengeance on people they don't like, competitors, ex-lovers, wives, etc., by reporting what suspicious transactions to SARS. In fact, if you go onto the SARS website, there's even a portal for doing it. It happens all the time, particularly in divorce cases. I'll get you back. I'll tell SARS about you. And what you have to say there is SARS can select you for an audit because they've had a tip-off. Yes. But just note, and we'll come back to this later in the lectures, there is a provision called the Promotion of Access to Information Act, PIA, which goes on along the lines of, if a government body wants information from you, you are entitled to all information that the government body has on you. So if you believe that somebody has been causing mischief against you at SARS, your remedy is through the Promotion of Access to Information Act, and we go to SARS and say, please hand over all details of this file. Because this common or garden SARS official doesn't know that. What he'll say to you is, we have information that leads us to believe. And you say, oh, really? Who told you that? They say, we can't tell you that. They can't operate like that. If they have information which leads them to a conclusion, they have to provide that information. Who said it? And you can say, well, that is the attorney of my soon-to-be ex-spouse, and please treat it with the disdain it deserves. It doesn't stop the inspection necessarily happening, but at least you've got the satisfaction of being able to tell them that somebody is causing mischief. But I'd get somebody who really knows what they're doing to do that on your behalf. Now, we're carrying out an inspection. A SARS official, may, without notice, go and inspect any premises where he believes that a trade or enterprise is being conducted, but only to establish the identity, whether the person is registered for tax, and whether the person is keeping records. Now, we saw this happen in the Grahamstown Festival years ago. It was actually quite funny. The SARS officials arrived at the village green. Man, you've never seen so many caravans get out of Grahamstown. I mean, everybody just ran. Prof. Gordon did it with a major flea market center in Bruma years ago. He said, I'm going for a walkabout. Well, I'll tell you what, you've never seen people run away faster. But what happens in malls and things is SARS officials arrive. They say, we're from SARS. And the answer is really, so what? Show me your identity number, your identity card. And yes, I am carrying on an enterprise. Here's my ID book, here's my tax number, I'm registered for tax, and goodbye. But here is another one from when you are working from home. SARS may not enter the dwelling house or domestic premises except to the extent that it is used for purposes of trade, because that is your private dwelling. Now, that is where SARS officials are out there just walking around. The next bit comes where you have submitted information to SARS and you are now given a query from SARS. Any SARS official can require a taxpayer, or even another person, to submit relevant material to SARS about their businesses. They can do it on a class of taxpayers, they can do it on individual taxpayers, providing they limit that information to the records that are required to be maintained by the taxpayer. And if you receive a letter like that from SARS, you have to oblige. You have to submit that information at your cost. But notice, the SARS official is still confined inside SARS. They've sent you a written request. That doesn't give them access to your books and records. That is normally, you've submitted a return, and now we want to check the information. So, you may also be requested to put it in under an affidavit, if that request is made by a senior SARS official, and there can be other requirements relating to revenue estimation. You have to then produce the information. And SARS may say to you, right, I want to interview you about that information in order to basically decide what is this information about, does further investigation, is it needed, is verification of the information needed, etc. Okay, but there is a caveat there in item 3, with SARS must state this with reasonable specificity. They can't just say, send me all your books and records. They've got to say, well, what am I here for? What's this about? What information do I want? They've got to actually put that down in writing before you are even required to give it. SARS may give extension for this, and you give the information in. Upon receipt of a document like that, the taxpayer has 21 business days to give a response. You can ask for an extension if you want, or you can waive the 21-day period and give it to them immediately. Okay? So that is how they get information. Also important in this is that the SARS is now required to keep you updated. You know, people have investigations, and this has happened for years, where SARS officials go to a taxpayer and they say, we want this or that information. You send the information in, and you don't hear anything from SARS for 2 years. Meanwhile, you're sitting there on drugs and swallowing Imodium and all that type of thing, okay? Because what's going to happen? Now they have to keep you updated. They have to respond to that information. Normally, when you've sent that information in, it's filed on e-filing, and SARS will look at it and come back to you and say, case closed, or send more information. What they can't do is keep completely silent on it. So that is a communal garden query from SARS. But now, what happens where we have inspection, verification, or audit? We have to say that authorization for SARS officials is required before they do audits or criminal investigation. Only a senior SARS official may grant authorization for a field audit or criminal investigation. Now, there was a lot of mischief about this, and you've got to understand your rights. Okay? What happens if a SARS official appears at your business and says, I want to conduct an audit? Out of the blue. Answer, where is your letter of authority to be out of your office, signed by a senior tax official? If you haven't got that letter, goodbye. Okay? You can't do that. They have to have permission to be outside of their offices. Okay? There were all sorts of other forms of problems where any old SARS official would report a matter to the National Prosecution Authority. That is for criminal investigation. SARS can't do criminal investigation. Now, today, that can only be done if the senior SARS official has agreed to it. Okay? If the official does not produce authorization to conduct an audit, a member of the public is entitled to assume that the official is not an official so authorized. I had this with a farmer up near Craddock a few years ago, where some SARS officials just pitched up on his farm wanting to conduct an audit. He phoned me and said, "What do I do now?" I said, "Hand me the phone to the SARS officials. Where's your letter?" "No, we were just passing by. We just want to quickly do this audit." Answer? Goodbye. You don't have permission to be there. So, on a field audit or criminal investigation, a SARS official must be authorized in terms of Section 41 to come and do an audit by his boss, the senior tax officer. He's then going to send you a letter and give you 10 days notice that they're coming. And you are entitled to respond and say, well, yes, this is done in normal business hours. The letter must show you the initial basis of what they're coming for. What are they talking about? What would they like to know about? So you can get ready for them. And you can waive the notice, or within 5 days you can say, look, I've got reasonable grounds for asking for another date. It doesn't suit me. I don't think that that's a particularly good tactic, because what would you say if you're the SARS official? It's trying to hide something, right? But they have to make an appointment. And even then, look at item 5. They come to your business. If it's at home, they can't go into the dwelling portion of your home. Now, when they come and do an audit, you have to be careful. Because in the old days, the lekker way of doing this was to get all pally-pally, right? And entertain them, give them the best. That was one way of doing it. And hopefully they'd be sympathetic and bugger off. I saw another guy who said, I've got a better way of doing this. We'll put them in the boardroom with the air conditioner stuck on hot. That'll get rid of them quite quickly. And you've got to be careful. First of all, know this. SARS has a zero gifts policy. You may not give a SARS official anything. What you are required to do is to say you must give them reasonable assistance, appropriate facilities. So give them somewhere to sit. You've got to answer their questions, give them the material, okay? And you're not allowed to obstruct them, assault them, refuse them, all the rest of it, but you can even charge them for all their photocopies that they want if you think it's getting a little bit upset. So they come and they do their audits. Then they go away and they make their decision. They must write, they say, we've conducted an audit, and they send you a letter, either saying, thanks very much, everything in order, or what are my findings? They must put that in writing. And they must give you an opportunity to give your views, okay? And you must reply as to what is going on, as to whether the investigation is to go further or what information they have. What they can't do is leave you hanging out there forever and a day. SARS officials can refer matters for criminal investigation. Now understand this. SARS cannot do criminal investigations themselves. They have to refer the matter to the National Prosecution Authorities, formerly Gerrie Nel and his buddies. So what's got to happen is they conduct an audit. They find that there are criminal offenses in what you are doing. They then only a senior SARS official can then refer that over to the National Prosecution Authorities, who will then decide if they're going to prosecute somebody for anything that is untoward in tax. So we don't often see that, but what I'm telling you is that SARS can't put people in jail. And this has been a political hot potato for years, because when they brought in the Tax Administration Act, they wanted like a tax court where SARS could expedite their cases against taxpayers who had been overcooking things. Okay? They didn't get it. and they were quite disappointed about that. So here's a summary. Anybody can be selected for audit at any time. You are required to be registered and keep records, etc. You can have an inquiry from SARS, a written inquiry, in which case you must respond to SARS in writing within 21 days. That is the end of that process, or it escalates further. So those are your cases where we have a written inquiry, which is basically a letter from SARS. You respond, you may be interviewed, there is then an assessment decision, and SARS can look at it and say there has been tax evasion here, we could be referring this matter to the national prosecution authorities. However, when it comes to a field audit, they can select anybody, but they can't appear. They first have to get permission to be outside of their offices. That is what we call the senior tax officer's letter. You have to be given notice that they are coming to give you an audit. The audit is then conducted in terms of the rules. No bribes, please, but you've got to assist them, right? We then have a letter of findings which says, are your tax affairs in order or not, or are we proceeding further? There is then an assessment decision, and there's even a decision potentially whether we're going to refer this matter for criminal investigation. Right. Don't worry about inquiry orders. We sometimes have judicial inquiries into tax matters. That's for the big stuff. The big boys go there sometimes, don't worry about it. But do we ever have to worry about search and seizure? Can SARS arrive at your business at any time? Now, you've got to have a control over this. SARS, when they brought in the Taxation Administration Act, seriously wanted search and seizure provisions. And the parliamentarians, I remember being there in Parliament when we discussed this at the Standing Committee of Finance. They said, no, that's Gestapo-like. That's an invasion of privacy. There have to be controls over this. SARS says, we need to be able to conduct search and seizure. So they said, okay, if you want to do search and seizure, you have to apply to a magistrate for a warrant. A senior SARS official has to apply for the warrant. It's an ex parte application to a judge or a magistrate, and to say to him, I need an order to go and be able to carry out a search and seizure on a business because I think that there is major tax evasion in this. The judge or magistrate will then, if there is reasonable grounds, if he's satisfied that there's reasonable grounds, they will issue, and those reasonable grounds would be that you failed to comply with the Act, that there's relevant material SARS needs. They will then issue a warrant which says, this is the alleged failure to comply, this is the taxpayer, these are the premises to be searched, these are the relevant materials that are likely to be found, and then SARS has 45 days to use that warrant or lose it, okay, to go and carry out a surprise raid. And that happens in the big contraband cases. But when they carry out search and seizure, there's even a procedure for that. Because everything has to be run. They have to produce the warrant, okay? Then we can have a look at the information, we can seize material, we can retain computers, we may make extracts of the books, okay, even if it is a ship or aircraft. But very importantly, SARS has to make an inventory of everything that they take away from your business. They must carry out the search with decency and order. No lining people up against the wall or any violence. They can take the police with. You cannot obstruct them from conducting their order. And then they must retain the material until no longer required, and their investigation is complete. Now, sometimes they arrive without a warrant, or their warrant doesn't cover all the premises that they thought they needed. Then, there is one obscure provision which allows SARS, a senior SARS official only, in the pursuit of relevant material, to take his investigation even further than a normal SARS official. So on search and seizure, if they've taken your books and records, you have a right to make copies, and you must also have the right to get your books and records back once their investigation is complete. So what are we saying about search and seizure? Identity cards, please. A valid warrant. Carry out the search in terms of the rules. Okay. Then those rules can be bent slightly by a senior tax officer. You can have copies of all your material that is seized, and the material must be returned to you on completion of the audit. Now, warrants and search and seizure raids happen very, very seldom. SARS has to be really convinced that there is something seriously wrong before they will ever ask for that. So what we've done in the first 3 parts in these lectures is what we've said is, look, we've introduced who are the SARS officials, who is the public, what is the relationship between the public and the SARS official, and who can do what, and your obligation to register and SARS's obligation to respect your rights as a taxpayer. This is an extension of the work that we're doing on tax administration, and what we are going to be talking about here is income tax assessments and what happens when SARS wants to get money out of you. So, you will send in a return when called for. We did that in the last lecture. They put out an announcement, they say, put in your returns. You file your returns, and then the process of collection of tax starts. Through the e-filing system, you will probably get what is called an original assessment within a couple of days. You've submitted a return, and all that will happen is that will be electronically captured, and they will send you a form back. It's called an IT-34, which is marked an original assessment. And it will have on it the figures that you have submitted per your tax return. Okay? It will have taxable income. It will have the calculation of the taxes paid, the penalties, the interest coming out at the end of the day with your final tax liability to SARS. So that's all reflected on your original assessment, which follows very shortly after you sent in your return. And then we also have a category of original assessments which SARS can issue even without having a return. They can say, in terms of Section 95, a taxpayer who fails to send in returns can be sent an original estimated assessment. That is where SARS looks at previous returns, other financial information, and they go, here is an estimate of your income. Here is the tax and penalties thereon. They are entitled to do that in extreme cases, but only in extreme cases. The problem with an estimated assessment is you are in for a position that you're going to pay a lot of tax, unless you then come forward and say, SARS, actually no, your estimate is wrong and I'm going to prove that it's wrong. That can be a hell of a job. Then there are additional assessments. When you have had a tax inspection, or they have found something wrong with your tax return, they will issue an additional assessment. That then replaces the original assessment as being the live assessment for that year. And it will probably, I will tell you this now, have a nice big fancy penalty on it as well, because you have not disclosed something. Then, what happens if SARS makes a mistake? Now, this is the problem. Oh, SARS made a stuff up on my tax return. So I phoned SARS and I said to them, you naughty fellows, please reduce my assessment. And somebody on the end of the phone said they would. And then they didn't. You know, this sort of thing. Now, a reduced assessment can only be given by SARS if you have successfully disputed an assessment in terms of the rules of tax. Okay, and that does not include that you have phoned SARS. there is a particular procedure that you have to follow. It can also happen if there is a settlement or there is a judgment. Okay, or SARS is happy that they have made an absolute stuff up and they've issued the assessment to the wrong taxpayer. But otherwise, you can't reduce an assessment generally unless you have contested it with SARS. The danger that so many people make in South Africa is that they receive an original assessment and they put it in a drawer and ignore it and think it's going to go away. You'll see from this morning's lecture, tax problems don't go away. So if you receive an assessment from SARS, between the lines you must be reading, take a measure. We've got to deal with this if we're not happy about it. Okay? SARS may reduce an assessment despite no objection has been received or noted. That very seldom happens. There can also be what's called a jeopardy assessment. Now, jeopardy assessment happen where in the informal sector. And this has happened so many times to SARS where they have found a taxpayer not even registered. Normally in a township, etc., making tons of money. Now they know if they assess that person immediately, deliver an assessment to that person, they will go to that address tomorrow and the person will not be there. They'll bug it off. And then, so you might have an assessment with a huge claim on a taxpayer, but are you ever going to get the assessment paid? Answer, no. So that is where they issue a jeopardy assessment in extreme cases. What a jeopardy assessment means is that SARS can walk in with an assessment which says, it's payable forthwith, either you pay me that money now, or I am attaching your assets immediately, in terms of a preservation order to make sure that the assets don't disappear. They do that in extreme cases. But SARS, importantly, bears the burden that you cannot have a jeopardy assessment unless SARS proves that it is necessary to have such an assessment. Estimation of assessments can happen where a person fails to submit returns or submits returns in a manner that is inadequate, and SARS must make an estimate based on the information that is available. It can also happen that SARS, and note that only with a senior SARS official, may agree in writing to an estimated assessment. Now you've got to be clever on this one and you've got to persist. What happens if I've got a case, I haven't submitted tax returns and suddenly my building burns to the ground? I've got no records, I've got no way of reconstructing anything. And to put in place forensic auditors and the like to come and sort it all out and go and rebuild your books and records is just not feasible. That is where you are at liberty to approach SARS and say, let's come to an estimate, an agreed estimated assessment, without putting the books and records in, purely to save money. So we do that on occasion where we have estimated assessments. Now, there must be a notice of assessment that must be delivered to the taxpayer, his name, address, and all of those details, okay, and particularly in the case of additional assessments, they've got to say, what is your procedure? On the assessment, they've got to tell you, what is your procedure for disputing that assessment? How do you take this matter further? SARS then has an internal regulation in 97 as to how many assessments they have issued. Don't worry yourself with that. SARS may withdraw an assessment, but if you look at withdrawal of assessment, look at it. Was issued to the incorrect taxpayer for the incorrect period, or there was an incorrect payment. Never work on the basis that a SARS official will simply agree with you that perhaps they should just withdraw the assessment and be done with it. That is a very dangerous thing to do. So we continue. And we say, how many years can SARS go back? Now, you guys have done prescription, right? In terms of law. if I owe you money and you take no steps to recover that money, what happens? After 3 years, the claim prescribes, and you can't claim that money. In tax, it's different. And you have this. SARS may not make an assessment 3 years after the issuance of the original assessment. That has now been increased to 5 years recently. Okay? So you basically work on the back that SARS can go back 5 years at any time. And they will go back 5 years. Okay? In most audits. But they're not obliged. That is if you have made complete and full disclosure to SARS. However, if we have to ask, when do assessments become final? Very important thing. If you've received an assessment and you don't dispute it in item B there, no objection is received from SARS, then once the objection period of 60 days is over, that assessment becomes final on the taxpayer. The taxpayer has no real right of recovery there, okay? And then it can only be set aside through the appeal and objection procedures. This is why it's very important, if you don't understand something that SARS has done, you must, as we do in LA law, go objection. And you have to lodge the formal objection through e-filing before you are even in the grounds of a dispute. Now, we then get to the issue of how do you make a dispute with SARS. Now you can see here how we are going to blow a few million rand on legal fees in a very little time. What we're going to say is, first of all, understand this. People say, the commissioner can't prove anything. The answer is, he doesn't have to prove anything. In tax matters, you have reverse onus. The burden of proof is on the taxpayer. So if SARS makes an allegation and you can't dispute it, haven't got the records, then the allegation stands and you pay tax on it. So effectively, you're guilty until proven innocent in tax matters. It's one of the only acts in South Africa where reverse onus applies. So then we say we want to dispute, and they say that's fine. We have rules for dispute resolution that are determined between the Minister of Finance and the Minister of Justice. And it starts with a taxpayer who is aggrieved by an assessment must make an objection. There is an objection mechanism on e-filing. And you have to do it within 60 days of receiving your assessment. You object. And one of the things that we see in terms of Section 104 is late objections get dealt with very heavily. And you have to prove that you have reasonable grounds for not objecting on time. And this can cause a problem. So what you always have to do in tax is, the moment that you realize that there is a problem, you shout objection. A taxpayer may not dispute anything in any other court or through any other meaning other than the Promotion of Administrative Justice Act, okay, in the form of a PAJA review. Have any of you heard of PAJA in your course? Okay, the Promotion of Administrative Justice Act. Promotion of Administrative Justice Act is it's not a very big piece of legislation, but what it says is this. If you are not happy with something with SARS, then, or any other organ of state, you may ask for it to be reconsidered by a court if you can find that the matter was not dealt with with the correct procedures. In any aspect. So if you're dealing with something with the municipality and they don't do it right, you go to court, you get a PAJA review which says, municipality, go and do your job again properly. You can get a PAJA review with SARS, and many people have done, which said, SARS didn't do the job properly in terms of SARS procedures. And that's all very fine and dandy to do that, but is all that's going to happen is SARS is going to come back at you and issue another assessment tomorrow. So it doesn't really work. So you may only dispute through the Income Tax Act. SARS receives an objection, and the objection is then sent back to the assessor, who then prepares a statement of case and sends it to a senior who reviews it and says either SARS is backing off, in which case the objection is allowed, or we're standing our ground here, in which case the objection is disallowed. Notice that that decision can only be made by a senior tax officer. So they come along and they must, by way of a notice, inform the taxpayer who's objecting what their decision is, whether they're going to take it further or not. So, once the decision has been made, they've got to send you a summary of the case, they've got to justify their decision, and they've got to say to you, if you're not happy with this, you must then appeal to the Income Tax Special Court. So, an appeal is then made to court for a case to be considered by a court in a court action where they adjudicate what SARS is being doing. Now, we can also, under 1075, come to an agreement with SARS. And I must stress this to you. Most of us are doing this today. The cost of litigation is so long, is so emotional, is so expensive, that what we are looking to do is to settle disputes by way of arbitration determined in terms of this act. So what have we got? An assessment is issued. The taxpayer can accept the assessment, pay what's due, okay, or recovery steps will be taken by SARS. Or the taxpayer can object, in which case a SARS senior tax officer has got to have a look at it and give you the result of that objection. If SARS accepts, they issue a revised assessment. If they say, no, we're standing our ground, they have to give you a notice of objection disallowed and that the matter has been sent for you to reconsider. You then would say, am I going to take it to court? With your objection, the SARS officers have got to give their reasons, and you may then say, I can take this matter to the High Court on review, which is that SARS hasn't followed the correct procedures, unlikely. Or I can take it to the Tax Appeal Board, that is the small claims court of SARS, for matters below 500,000 Rand. For various reasons, people don't go there. Or I can go to the Income Tax Special Court. What happens in the Income Tax Special Court is the merits of the case are put before a judge who is experienced in tax matters and is assisted by 2 assessors. And we have a court case about it. And that will cost you not less than R1 million in legal fees to contest the matter. And then, if SARS loses, they will probably say, I am appealing the case to either the High Court, full bench, or to the Court of Appeal in Bloemfontein. Normally, it bypasses the High Court and goes straight from the Income Tax Special Court to the Court of Appeal in Bloemfontein. Another R1 million of legal fees. And then, finally, if it is a constitutional matter, you can have it heard in the Constitutional Court, but the Constitutional Court, there are very, very few cases that they will hear on tax because they are not generally constitutional matters. So what happens when you look at that? You say, my God, the only person who's going to get rich out of this is going to be the lawyers. Millions. And this is what makes a mockery of studying tax, is that so few cases go to court anymore because nobody wants to pay the legal fees or get involved for so long. So what happens? How do we solve that problem? We go to what's called ADR, Alternative Dispute Resolution Procedure. That is an internal procedure at SARS, and basically what it says there under 143 is there are sometimes circumstances where the strictness and basic rigidity of the act be tempered. And we can have parties in a dispute, and they may agree to try and resolve this thing through negotiation. So what happens is we go to SARS and we say, we'd like to talk in the interests of good tax management and in the interests of saving SARS the costs of litigation. We want to avoid going to court. Let's have an ADR hearing. It's handed over to a separate team, and we have a haggle about it. Okay? And what we're basically saying is that there are circumstances in the Act which we can justify, allow SARS to enter into a settlement. So, we have a haggle about it. Now, what's important about this is we basically come up with a number to settle it. So the assessment might be 10 million. SARS will say, we reckon that a reasonable settlement for this is 2 million. Now, a judge can't do that in a court. A judge can only say the assessment stands or the assessment falls. SARS, in one of these negotiations, can say, we're prepared to settle this matter in a written agreement between the parties, settling the matter for a figure of 2 million or 10 million, or whatever that might be, depending on how good your negotiation is. And the senior SARS official then says, if you forfeit all your further rights to objection and appeal, you've got to stop now, we will stop now, we'll enter into a settlement agreement, and we will have a final agreement to settle this on all the material known facts. You pay, sign the agreement, and walk away with your shirt on. Okay? And we will not alter this matter unless you have, we will not alter this agreement unless you've been dishonest with us. Simply settling the whole thing out in a nice, easy manner. So to finish this cycle, off you go. Assessments are issued. The taxpayer may pay, or recovery's tax is taken. You can go and litigate, or you can have an ADR. Then we have to talk about the payment terms and your ability to pay. Now, when we talk about ability to pay, that's going to be in the next lecture after tea. Right, now, this is the final lecture in the tax administration series. And what we're going to be looking at here is the very important skills that you have in life when you can't pay your taxes. And I can guarantee you that someone, somewhere in this class will face that position where they've got SARS on their back. At some stage in their life, how do you ever get them off your back? And it's all according to procedure. If you play this right, you can get away with blue bloody murder, as far as I'm concerned. Get it wrong, and hey, you could go to jail. So it's all very important how you behave with SARS and understand the system so that you can play the system. So the system is actually there to protect you as much as it is to protect SARS. So we start off with an assessment was issued. In the normal course, the taxpayer accepts, he pays what is due in terms of the assessment. If he doesn't, recovery steps are taken against you. Okay? But there might be litigation involved, in which case we've got to talk about what do we do about the claim that exists. Whether you're going to go the ADR route or whether you are going to go the court route. And we have to talk about what happens on extension of payments and a few other things. Now, from section 151 onwards comes the question of the payment of taxes. So we have a definition firstly of a taxpayer. That is a person who is chargeable to tax. But notice it also includes provisions with regard to representative taxpayers and responsible third parties. Now, when you get to 153, you get the definition of a representative taxpayer. Representative taxpayers can be appointed in terms of the Tax Act, and they can also be where you are a PAYE vendor or a VAT vendor, person who's collecting taxes on behalf of your employees or on behalf of your customers and paying them over to SARS. So they are defined in 153. And the liability of the representative taxpayer is also defined in 154. So you can't say, well, that's not my taxes. I plead ignorance in this matter. If you're a representative taxpayer, you are responsible for taking that SARS from that money from the taxpayer and giving it to SARS. And what is important in that is that the representative taxpayer can be personally liable for taxes. If there is tax payable and the representative taxpayer in his capacity fails to pay it over, please, please, please always pay tax in a representative capacity. You pay that to SARS on due date. Because if you don't, you're facing a theft charge and a jail term for holding somebody else's taxes that you have deducted from them and not paying it over to SARS. It's one of the very worst things that you can do in tax, believe you me. That's high jump material. Now, basically what happens is that you are liable to pay it over in a single amount on the due date to SARS, normally electronically, okay? A senior SARS official may, if there are reasonable grounds, allow a taxpayer not to pay the full amount, as it may dissipate the taxpayer's assets. But there must be a notice. You can't take the law into your own hands on this. You have to go with the Act. If you're going to depart from the Act, then you have to approach SARS. So, there are the provisions. You may apply for payment in installments, but you've got to have a notice from SARS. Don't think that you can just pay it off like an Edgar's account when you feel like it. You're going to land into hot water with SARS very quickly. If SARS is of the view that a taxpayer is withholding money unnecessarily from them, they can then apply for a preservation order. Preservation order says, we are going to attach all your bank accounts and everything, and we are going to keep that money in abeyance until we have sorted this amount out. Be careful, be very careful on preservation orders. If you're not cooperating with SARS, that's how they catch you. They freeze your assets. Then you can't have access to them either. Also important in all of this is your obligation that you must pay pending objection and appeal. You can say, I don't owe that money. SARS says, oh, well, unless you come to us and you actually say, I am a taxpayer of good standing. My tax affairs are up to date and there's no risk of dissipation of my assets. I'm no risk to you. I therefore want the money to be, an extension to be granted until this litigation is over. Now that would sound like a good idea, but that litigation might take 10 years and you might lose. So if you lose a tax case after 10 years, you are going to pay the following. You're going to pay your own legal costs. You're going to have a court cost award against you from SARS for their costs. Then you're going to pay back the tax and then 10 years of interest. That's a bitter pill to swallow. And that's why when it comes to alternative dispute resolution, which we spoke about just now, in so many cases, what happens is we say, I can't. Forget it. I'm not going into this matter. I'm going to ask for ADR. I'm going to get out of this with my shirt on, and I'm going to settle it now. You may ask for an installment agreement to pay off taxes. That's fine. It's perfectly in order. And a senior SARS official may sign it. But then you have to keep to the installment agreement. If you depart from the installment agreement, it becomes null and void. You may always go along and say to a senior sales official, I need to renegotiate it. Please, by all means, do that. But what you must do in those instances is you must go and speak to the guy. You've got to keep the eye of communication open on this. Now, don't think you can run away from it. The period for collection of tax, SARS has a 15-year prescription period. So I've seen taxpayers who said, I'm going to Australia. I'm not going to pay my taxes for the last year. I'm going to bugger off. Then they go to Australia, and they don't exactly get on with those Aussies. They speak in a funny way, and they have funny sports procedures, and they chase kangaroos. Right. So we come home 10 years later. We can't take it in Australia. And we go to SARS, and they say, that's really funny. There's a balance from 10 years ago, plus interest. I'll say, well, Whistle, you didn't recover it within 3 years. No. SARS has a prescription period of 15 years to get that amount back. And they may, if you don't pay your taxes on time, apply for a civil judgment. But they've got to give you 10 days business notice to say, we're getting a civil judgment and we're coming to collect your taxes if you don't pay on time. Then third parties can even be required to pay your taxes on your behalf. But that's only where they've been party to the crime. But watch out this. Liability of financial management for the payment of your debts. Where a person controls money and they are negligent or fraudulent and money is not paid over to SARS, that person can be held personally responsible for the debt. Now that financial directors watch out for. If you try and nick the company's money, there's a provision there that allows SARS, if you have gone and dissipated those assets, to recover it against you personally. And shareholders of companies as well, also be very, very aware and wary to this. If you raid your company's assets and leave SARS unpaid, they can recover that amount against you personally and hit you with a theft charge. So be very careful about just raiding the piggy bank and running off with the assets. There is also a liability for transferees of debts and people who help in the assist in the dissipation of assets. So I might get myself into financial trouble. So I say, hey, I've got this life partner. We used to call them girlfriends. I transfer them all that money into her account. Say, keep it for me. SARS is after me. If they detect that transfer and somebody is holding money on your behalf, they become personally liable for the debt as well. So be careful of ever holding somebody else's assets. All the time that your tax remains unpaid, interest is accumulating at the daily rate and the current interest rate. This adds up very quickly, and there's no in duplum rule in tax. In civil matters, when the interest exceeds the capital, the interest is capped at the capital level. Not so in tax. Quite often in tax, we have old cases where the interest bill is greater than the original capital amount. It can be quite terrifying, okay? That interest sits there. So, what are we saying? An assessment is issued. The taxpayer accepts payment, or you litigate. If you want to litigate, or you can't pay, you have to ask for an extension. But what happens if you can't pay at all? This is where it gets very exciting. I like this. The write-off or compromise of a tax debt when you really can't pay. Where you've had a business, you knocked up a tax liability, and before it was assessed, suddenly you lost everything. Now what do? You go to the special provisions in the Act which deal with it, the compromise provisions, and they say, There are times where SARS can depart from the strictness and the rigidity of the Act. Why? Because if SARS liquidates a taxpayer and there's nothing there, SARS has got to pay the liquidator. They can make it even worse. And they're going to take years to get their money. So now everybody says, hang on. As often happens in any case with a big bad debt, the problem is as much for the creditor as it is for the debtor. So now we've got to find a way of solving it. Now, there may be a temporary write-off of a tax debt where it is uneconomical for SARS to pursue the matter. But that does not absolve your liability. Okay? There may also be cases where SARS writes it off as uneconomical to pursue. They just write it off. Those provisions are really there to help SARS in administering their debts and things that they're not worth pursuing. But where it gets exciting is the permanent write-off of a tax debt. I can't pay. Now, believe you me, in all commercial matters, I call it the Wailing Wall. You go to your creditor and you say, sorry, can't pay. Your problem. Okay? And that includes SARS. That's incredible, isn't it? You can say, I can't pay you. Now, a tax debt is irrecoverable when SARS has first explored the debt and found out that they've investigated it and it's truly not payable. And there's an obligation on SARS to at least go out and investigate the matter and see that the money cannot be recovered. Then a senior SARS official may authorize a compromise. Okay, and this starts off with a request from the taxpayer to say, listen, I don't have the wherewithal to pay you. And you must be able to satisfy SARS that that is truly the case. I can't pay you. I'm sorry, but you've got to be able to back that up with your true position. And SARS will then look at the taxpayer and say, is this one we could compromise? Have they done this before? But notice that SARS will never, ever compromise a tax debt. Last line. If the taxpayer does not have their tax affairs up to date, they're not allowed to help you in those circumstances. So that we make an application and we say, SARS, will you help us? And SARS says, look, we can help you. First, are your tax up to date? Secondly, are you facing a liquidation claim from your creditors? If all of your creditors are liquidating you, we're not going to give you a concession unless everybody else does. But SARS must first look at the case and say, does this warrant a write-off? And then we sign an agreement and it's written off. Provided that, look, you've made full disclosure. If it later is found that you've given incorrect information to SARS, then sorry, do not pass go, do not collect 200. Now, at the end of the day, final thing on this section that we're doing here, before we're going to do a practical example on the board, we have administrative penalties in the Act. Now, 30 years ago, I was a SARS official. I did my national service as a tax inspector. And in those days, we used to have a coffee table book with the best excuses by taxpayers. And if they made the coffee table book, we used to let them off. The best bullshit reasons that ever came along. Today, they don't have that. Today, we have the Tax Administration Act, which has a menu of penalties that must be imposed on taxpayers, with no grounds to get around them. And they are from Section 208 onwards. Firstly, is your penalties for not submitting a return. There is a per month penalty that is charged for every month that you are late on your return. You will get a statement. Your penalties are running up because you haven't filed a return, and so on and on it goes. That's the first surprise. The second surprise, and the most dangerous thing in tax, is your understatement penalties. There is your menu. And when they have a case, they look it up on the menu and they say, what type of tax evasion are we dealing with here? And they impose the penalty. So, if you had no reasonable grounds for the tax position taken, you're going to work out the tax, add 50%, then add interest. If it is gross negligence on the taxpayer, which is I simply didn't declare it, 100% penalty. You take the tax bill, then you double it, then you add the interest. Do you see how it all adds up? So it can easily add up to more than the original amount that you received. But what is important with the understatement penalty provisions is there's no way for us to write a letter to SARS and say, oops, I'm sorry. That's taken out. That is not a permissible reason for getting away from penalties. You've stuffed up, there's the penalty, now pay it. So one has to be very careful with that. SARS must impose the penalty. There are very limited grounds for getting around things. But pick up that one in section 221, which is that there is the opinion of a tax practitioner. So you're doing something that is vague in tax. You come to a tax practitioner like me and we say, okay, I will write you an opinion that in my opinion that amount is deductible or you're not paying tax. If you can show the opinion of the tax practitioner, then the penalty doesn't apply if you excluded it. But then the problem becomes mine as the tax practitioner. I will only write that opinion if I really believe in what I'm saying. And if you have given me full disclosure of all material facts. And in most cases, I try to actually not write those opinions. I don't like them because it transfers the risk of the opinion being wrong onto me. So I'm going to charge you a lot of money for writing an opinion like that. But it is a way of getting away from the penalty. And then you have the criminal offences. Now, I'm not going to read them all to you in a lecture like this. Right? They are all the different forms of tax evasion, then get listed in terms of section 234. And on each count, we are saying that the taxpayer on conviction can be subject to a fine or imprisonment for a period not exceeding 2 years per count. So you can easily go to jail for tax evasion for 10 years. And that's not only limited to the taxpayer, there is a similar provision with regard to the advisors. If they are found, they can go 5 years per count, that you have assisted somebody in the evasion of tax. So that makes the likes of me, who's a tax practitioner, very careful about what I will say to my clients in what I'm doing. Right. So we have a look at that and we say, that's a difficult one. Right. Is where we admit to a tax problem. Go to SARS and we say, I'd like to pay back. This is one of the provisions that Pravin Gordhan was quite famous for, actually, for designing this. And it gives the taxpayer a chance to come clean, a formal chance in terms of a formal procedure. So sitting in Pretoria is a special unit of SARS called the VDP unit, Voluntary Disclosure Program Unit. They operate separately from SARS. And through e-filing, you can reach them and say, I want to confess a tax sin. But you can't confess unless you are already under audit by SARS. So, when SARS arrives and starts doing the audit and they find something, you can't say, I now confess. you're up for the penalty then, right? You've got to do it before SARS comes along. Requirement: you must be voluntary. It must involve an amount which is previously required to be disclosed. You must make full and complete disclosure of the understatement, and it must be made in the prescribed form and manner over e-filing. So we send them a schedule and say, SARS, here is all the information that we need that I haven't disclosed. I'm putting it back to you, SARS, and there we go. And if SARS agrees to that, then we give you a relief. You pay back the tax, pay back the interest on the tax, but there will be no criminal prosecution, which is very useful for VAT and PAYE infringements. And there will be no understatement penalties, that schedule that I looked at earlier. So by doing this, you are halving your risk. We'll have a look at it in a moment. We enter into a voluntary disclosure agreement with SARS, and it's a written agreement. They say, you've disclosed this amount, and if you pay this amount, here's the penalty and interest, there's a figure, pay it, end of story, the matter is confidential, the fact that you stuffed up your tax remains confidential between you and SARS. And that agreement will be final and binding on you unless you have failed to make full disclosure. So, what do we do? If you have a problem, you own up, and you own up quite quickly. Right. Now, this leads on to another matter which you must be aware of, which is the general anti-avoidance regulations in tax. Now, this is contained in Section 80 of the Act, and I want to bring a couple of aspects to it. This material has been in the statute book now since 2007. It's never been to court. It doesn't need to go to court. It acts as a deterrent to the taxpayer. But one has to understand what is tax planning and what is tax evasion. That's what the discussion for the next 15 minutes is going to be about. So I like spectrums. Here goes with one. Put up a line and we say, if you never pay your taxes, you will go to jail if you're caught. And if we pay all our turnover in taxes, you will go insolvent. We have to live somewhere between the two. So the likes of Ari Onassis, who was a complete crook, would go to jail, and the likes of Trevor Manuel, who's always going on about people claiming tax deductions, he'd go insolvent. Right. So we've got to live somewhere between the two. They're conflicting forces. And you've got to understand where you stand on that spectrum. Now, there are all the different terminologies that we use in this whole thing, from left to right. And we've got to have a look at them and say, where does it all start off? Now, 40 years ago, when I was a tax student in this lecture theatre, we used to quote cases like Lord President Clyde. This is a 1937 judgment. He says, it is trite that His Majesty's subjects are free, if they can, to make their own arrangements and cases to fall outside the Taxing Act. They incur no legal penalties and, strictly speaking, no moral censure, if, having considered the lines drawn by the legislature for the imposition of taxes, they make it their business to walk outside them. That's fine. But if you're going to go into court with that today, let me tell you, the court case will result in one thing. As they say in Afrikaans, opgefok met kostes. You're going to lose. Okay? So we take this further forward. And we say, that doesn't really apply. But what would be interesting is to look at what is a tax transaction in terms of the rules of infrarum legis. And we go back to a fundamental judgment that hasn't been really rewritten for 100 years. The parties to a transaction endeavor to conceal its real nature. They call it by a name or give it a shape intended not to express but to disguise its true nature. And it is the job of the court to unravel that disguise and tax a transaction as to what it truly is and not what it purports to be. In such cases, they say, the Latin maxim applies, plus vale quod agitur quam quod simulate concipitur. What does that mean? Any Latin people in the class? In pure South African terms, no bullshitting. You can't window dress a transaction. And so often when you hear of people's tax schemes, is all they are doing is that they are hiding the true arrangement. So if I go, for example, and I say, I've got a tax problem. I'm paying huge amounts of tax. But, hey, my daughter's not employed at the moment. She's got no taxable income. So I say, hey, Jess, do you mind if you open a bank account? Jessie Lester. You give me the details on the bank account and the card, and I'll put my money in your bank account. Therefore, the interest will accrue to a taxpayer who's not got any liability because they're unemployed. And you haven't passed the tax threshold. But I've got the cards, I've got the control over the account. What am I doing? I'm bullshitting. And if SARS uncovers that the true arrangement is that it's my account, do not pass go, do not collect 300. You will never, ever win a case like that. This was a judge called Lewis, J.A., in the appeal courts nearly 10 years ago, said this test should go further. And it should look at the substance of arrangements, and if you are in any transaction which is there for the purpose of evasion of tax, well then that is a simulated transaction. And she made quite a stir about this, that saying, parties always perform in terms of their transactions in a way that they show that it's not simulated when it is. And she's basically saying the charade of performance is generally meant to give effect to the simulation. Well, this didn't really add much ground to the debate. What we've got to say is, if the purpose of a transaction is only to be for the object of allowing for tax evasion, then it will be regarded as a simulated transaction and it will be ignored. So the first inquiry in every tax matter, and it often doesn't go further than that, is quite simply, have the parties fabricated a transaction to get around their taxes? If there's any suspicion of that, then you have an infraudum legis transaction, goodbye. The next step that we take with this is the substance over form transaction. Now, the doctrine of substance over form was look at that, 1936. That's where we say, we see your transaction, and we know that you're behaving in that manner, but actually, we know what you're doing, right? The substance of the matter, of the arrangement is this. What it is then, is that SARS is making it up as they go along. And this has been thrown out by the courts. They said the sooner this doctrine is given its quietus, in other words, shut up, that is for the better, because the doctrine of substance over form is nothing more than substituting the uncertain and crooked cord of discretion for the straight and golden meter of the law. It's not the end. Form is not the end. Okay? Now, this is not really changing tax planning today in new cases like NWK and all the rest of it. It's not making a huge amount of difference. In anything that you look at in business with tax, the starting rule is you have to put the transaction there in a manner that is open and honest. Then apply the law to it. If it's not taxable in terms of the law in an open and honest version of the transaction, then so be it, good luck to you, all power to you. But if you are bullshitting and fabricating the transaction to disguise it as something else, then forget it, that is tax evasion, and you're going to get yourself into a whole lot of trouble. So those are the two ends of the scale. But in the middle of it, is what some people call legislated substance over form, which is the General Anti-avoidance Regulations of the Income Tax Act, Section 80 GAR, General Anti-avoidance. And there are various provisions here of the different parts of the Act. It goes on and on. You cannot believe how long it goes on for. You could write a master's thesis about this quite easily. Many people have, probably even take it up to a PhD. But let's give you a working understanding about what it is. If you design a transaction, the first thing that you look at is it an impermissible tax arrangement? And there is the definition of an impermissible tax arrangement. It was not entered into for bona fide purposes, other than to get a tax advantage, or the transaction lacks commercial substance, or it was entered into a manner not normally for business purposes, or it was not at arm's length, or it would frustrate the purposes of the Act. So here is a transaction. Particularly in this, we look at transactions that are not at arm's length, or transactions that lack commercial substance. We then go to the second provision of that Act, which is B. B says, if you've triggered off an impermissible tax arrangement by invading A, then B will apply, and SARS can do any of the following things to you. It can disregard the transaction, combine the transaction, tax other people, look at connected persons, relocate income, recharacterize income, treat the arrangement as if it had never been entered into, okay, or make compensating adjustments. So what happens in Section 80B is once 80A has been enacted, that you've got an impermissible transfer, SARS can then go and tax in terms of 80B. If one then goes to 80C, that is, when does a transaction lack commercial substance? Now, lacking commercial substance in terms of C then activates A, then activates B. So in the third part, they say a transaction lacks commercial substance if it has no business risk or net cash flows. In other words, cash is just turning in a circle. Or the beneficial ownership of an asset is different to what is described in the contracts. Or the legal or economic effect is inconsistent with the legal form of the transaction. Or you are involved in round-trip financing or a accommodating tax-indifferent party, or elements of the transaction have the effect of cancelling each other out. Now, we need to try and explain what on earth they are talking about. What they're doing is basically saying, if you have a transaction where money is sent in a loop, so for example, I've got income here, and I want to send it to Mauritius, enter into an agreement, and my money suddenly lands up in Mauritius. It's not taxed in Mauritius and it's sent back to me, for example, as a dividend in South Africa. That is a lack of commercial substance in the first place. Why? There's no risk. I owned that money all the way through. In effect, I simply sent it out in a loop and it came back. There was no risk. Is all I'm doing is A, bullshitting, and B, I've got a lack of commercial substance in what I'm doing. There was no reason to do that. So that would be either not entered into for bona fide purpose, or it would lack commercial substance, or the next two. The round-trip financing, I've sent it in a circle, that's D. Or my company in Mauritius has a 3% tax rate. That's what's called a tax-indifferent party. So they don't mind paying the tax on it because their tax is either negligible or nil. Or we have the effect that the transactions are cancelling each other out and I'm landing up in substantially the same position. Now, those three provisions, those are the things that we have to watch out for whenever we get into one of these discussions. This is all stuff you can write a thesis on. But what you're saying is, we're wanting to rather stay with the basics. You can't just send money here, there, and everywhere to companies that you control yourself all over the world. Because that can be an infra majors transaction, it can be an impermissible tax arrangement because there's no bona fide purpose to what you're doing. It can lack commercial substance, or we can have tax in different parties, or we can have round-trip financing. Any of those consequences puts the commissioner in a position that they can strike that transaction down. So a lot of the stuff that we used to be doing 30 years ago, before this legislation came in, used to identify these transactions and say to people, look, you can get away with it. That's your good luck. But when I wrote income tax at Rhodes University 40 years ago, the Income Tax Act was only 70 pages long. Today it's 700 pages long. All with sniper provisions everywhere, do this, do that, do the next thing. So when you talk to entrepreneurs, you're saying, in conclusion really to what the lectures I want to do today, is to say, look, concentrate on your business. Don't even get involved in all of this stuff. What you are wanting to do in your business is to say, concentrate on making profits and keeping clean of the tax man, using the entities that are available for SMEs, particularly the small business corporation. And once you outgrow the small business corporation, get yourself a tax advisor who has studied the 700 pages and can help you. And then you can be the likes of Apple, who can put your company, have companies in Ireland that pay 1% tax, or companies in Mauritius. When you can pay those people to do that, when you've got a big enough tax liability that makes it worth your while to go tax planning, that's the big message.